From memory, the conditions are they're a member of TDA. The government has good reason to believe they're a member of TDA. The government has good reason to believe that they are 14 years of age or older. And the government has good reason to believe they are not an American citizen or permanent resident alien. If those three boxes are checked, bam, you're out under the Alien Enemies Act. That's the total extent of judicial review. It is well established that the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. But due process is limited, as they say here. So these detainees are entitled to notice and opportunity to be heard appropriate to the nature of the case. Is this a murder case where you get lots of due process? Or is it a deportation of a terrorist case in which you get very minimal due process? The due process is not the same in all cases. It's the due process that's appropriate to the nature of the case. This is the weakness of the Supreme Court, which would be fine if they were dealing with courts acting in good faith. But they're not. They're dealing with courts who have TDS and are acting in bad faith simply to obstruct a president and policies they do not like on a personal level. Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding, gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you. All right, first thing first, the April 7th order from the Supreme Court that was against Judge Boasberg, right? It vacated his order, his temporary restraining order, because he, in fact, lacks jurisdiction over these cases. So he had issued a temporary restraining order against Trump. Trump went to the Court of Appeals, the District of Columbia Court of Appeals. They said they didn't want anything to do with it, and he appealed up to the Supreme Court, and the Supreme Court came down in Trump's favor. This matter concerns the detention and removal of Venezuelan nationals believed to be members of Tren de Aragua, an entity that the State Department has designated as a foreign terrorist organization. They are terrorists. They are terrorists. There, I want it to look more like that. Initially, the detainees, the TDA people, sought relief in habeas, among other causes of action. Habeas meaning if you're detained by the government, in the place of the district of your detention, you can be asked to be presented to a federal judge, and the government has to explain why they're holding you. That's what habeas means. But they dismissed their habeas claims. The reason they dismissed it is because they didn't want to bring their claim to court in Texas, which is where they were being held. They wanted to bring their claim to court in the District of Columbia because they wanted to judge shop. And then when they got to Judge Boasberg's court, he said, listen, if you insist on a habeas claim, I have to send this back to Texas. So why don't we make up some other reason why you're here, and then I'll claim jurisdiction over this case. And that's what he did. And that's what they did. On March 15th, 2025, Judge Boasberg, the unelected black-robed, tyrannical, inferior district trial court judge, Boasberg issued 2 temporary restraining orders preventing any removal of the named plaintiffs, the 5 people before him, as well as preventing removal under the Alien Enemies Act of a provisionally certified class consisting of all non-citizens in U.S. custody who are subject to the Alien Enemies Act. Universal jurisdiction claimed by this Judge Boasberg. The D.C. Circuit Court of Appeals denied Trump's emergency motion to pause Boasberg's order. The government then applied to the Supreme Court, seeking that we vacate the order, not just pause it, but obliterate it. The Supreme Court says we grant the application from the White House and vacate these lawless TROs. The petitioners challenge the government's interpretation of the Alien Enemies Act and assert that they do not fall within the category of removable alien enemies. But we do not reach those arguments. This is important. The Supreme Court is not reaching a substantive argument here. They're not saying these deportations are inherently unlawful. They're saying the challenges to removal under the Alien Enemies Act, a statute which largely precludes judicial review. Where's my red pen? Largely precludes judicial review. The Alien Enemies Act largely precludes judicial review. This is a warning to other judges that, hey, this is not really within your authority. You think Judge Charlotte Sweeney interpreted this order in its plain language? And if there is to be a challenge, it must be brought in habeas, meaning that you have a right to be shown into a court or have your argument presented to a court. It doesn't even need to be in person. And the government has to explain why they have good reason to believe they're detaining you or under the Alien Enemies Act, deporting you. For core habeas petitions, jurisdiction lies in only one district, the District of Confinement. So in Boasberg's case, he had no jurisdiction. The people were being detained in Texas. The detainees here are confined in Texas, so venue is improper in the District of Columbia. The detainees also sought equitable relief against summary removal, although judicial review under the AEA is limited. We have held that an individual subject to detention and removal under the statute is entitled to judicial review as to questions of interpretation and constitutionality of the act, which was, by the way, affirmed in the case they cite, Ludecky. The most recent case on the Alien Enemies Act by the Supreme Court affirms its constitutionality. It's therefore presumed constitutional until the Supreme Court reverses itself. You think that's how Judge Charlotte N. Sweeney sees it? No, she sees this inch as a mile, a door to be kicked open that, well, if it's subject to questions of interpretation and constitutionality, then I can order anything I want about the Alien Enemies Act. We'll see that in her order. But they can ask, like habeas, to be shown in front of a judge. The government has to explain, yes, you meet the conditions of the proclamation of the Alien Enemies Act. For example, one condition inherent to the Alien Enemies Act is that it only applies to people 14 years of age or older. So you can ask for the government to have to explain in court that they have good reason to believe you're 14 or over. That's it. That's the extent of your habeas relief under the Alien Enemies Act, that you meet the conditions of the proclamation. In this case, let's see, do they define it here? They don't bother, but I can tell you from memory, the conditions are they're a member of TDA. The government has good reason to believe they're a member of TDA. The government has good reason to believe that they are 14 years of age or older, and the government has good reason to believe they are not an American citizen or permanent resident alien. If those 3 boxes are checked, bam, you're out under the Alien Enemies Act. That's the total extent of judicial review. The government expressly agreed that TDA members subject to removal under the Alien Enemies Act do get judicial review. Yes, they're getting all the due process to which they are entitled and more. The White House is not saying you don't get due process. The White House is just accurately describing the due process called for, the very minimal due process that you're entitled to under the Alien Enemies Act proclamation. It is well established that the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. But due process is limited, as they say here. So these detainees are entitled to notice and opportunity to be heard appropriate to the nature of the case. Is this a murder case? where you get lots of due process? Or is it a deportation of a terrorist case in which you get very minimal due process? The due process is not the same in all cases. It's the due process that's appropriate to the nature of the case. In this context, AEA detainees must receive notice after the date of this order, which was April 7th. So the proclamation itself is deemed by the Supreme Court not to be sufficient notice by itself, although it should be. Notice that they are subject to removal under the Alien Enemies Act. The notice must be afforded within a reasonable time. What's that mean? Well, the Supreme Court doesn't say. So all these unelected, black-robed, tyrannical, inferior district trial court judges are able to say that whatever time the government offered was not reasonable. Every court gets to make its own definition of reasonable in this context. This is the weakness of the Supreme Court, which would be fine if they were dealing with courts acting in good faith, but they're not. They're dealing with courts who have TDS and are acting in bad faith simply to obstruct a president and policies they do not like on a personal level. Notice must be afforded within a reasonable time and in such a manner as will allow them to actually seek habeas relief in the proper venue before removal. All this wishy-washy language just kicks the door open for these unelected, black-robed, tyrannical, inferior district trial court judges abusing their limited authority under our constitutional order. For all the rhetoric of the dissents, this is where Sotomayor was saying, oh, if this can happen to terrorists, it can happen to anybody, even American citizens. All today's order does is confirm detainees subject to removal orders under the Alien Enemies Act are entitled to notice and an opportunity to challenge their removal, which the White House has always agreed to. The only question here in this decision is which court will resolve that challenge. This is important too. There's one question here. Does Boasberg have jurisdiction? Can a District of Columbia federal court be issuing these restraining orders involving detainees being held in Texas? All the rest of this flowery language is what we lawyers refer to as dicta. Statements not relevant to the core of the question. The only question, which court has jurisdiction? Anybody reading much authority into the rest of this, anything that's not addressing this single question of jurisdiction, is over-leveraging this case in an obviously inappropriate way, as any judge or lawyer would know. The only question is which court will resolve that challenge of notice and opportunity to challenge the removal. For the reasons set forth, we hold that venue for these people being held is in the district of confinement. For these people, that's Texas. So this order from the Supreme Court is not favorable to the Trente Aragua, to Judge Boasberg issuing these restraining orders. It's favorable to Trump. The application vacates the orders of Judge Boasberg. It's done. He does not have jurisdiction. So this, you'll see it referenced as Trump versus JGG in Judge Sweeney's order. She acts as if this is in support of the TDA detainees, which is the opposite of the truth. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.